Okay, moving on, license law revisions. Like I said, we have been in discussion with the Division of Real Estate for at least 2 years on some license law issues, a lot of them just cleaning up the Ohio Revised Code and the license law provisions. Other things we wanted changes or the division wanted changes. Most of our discussions and most of the areas we did agree on with the division. Most everything, not everything though. What is in the budget bill are the things that we agreed with the division on. And so that's what I'm going to talk about today. There were a couple issues that we did not reach an agreement with the division. We agreed to disagree, and we're still going to be talking to them about those issues. But I'm going to cover the ones that we did agree on, the more important ones here, and kind of go over those quickly. The first one, it limits lawsuits based on imputed knowledge. And let me kind of go over with you what imputed knowledge is. And this really came out of a case up in Cleveland. And it was this situation. A home was listed. It went into contract, and the buyer did an inspection and found out that there were foundation problems. It didn't close. It never sold during the term of that listing. Then 4 years later, it was listed again with a different brokerage company. And the buyer who ultimately bought this home was represented by an agent with that same brokerage company that had it listed 4 years earlier. So the buyer rep, when this buyer bought, was with the same company. Different branch office, didn't know the listing agent. As a matter of fact, at this time, the listing agent had died, that listing agent who had it at that time. So this was a situation where a buyer bought this property, did some inspections dealing with foundation issues, but really didn't look into it as well as they should have. Anyway, bought this home, serious foundation problems. I mean, like sliding down the hillside. So serious they had to move out, and they sued. Part of who the parties that they sued was their brokerage company, the buyer broker who represented them. And part of the issue with the buyer broker was this imputed knowledge. They basically said, brokerage, you had information in your files. Yep, it might be at a different branch office, and it may be from 4 years earlier, but there are information that you have in an office of your company that discloses foundation problems with this home. My agent who represented me, who's now with, who's with a different branch of your company, should have known and should have told me. The brokerage knows, that agent should have known, I should have been made aware of these issues, and I wasn't. And they prevailed against the brokerage company. They did. It was actually then settled, but they did prevail at the trial level. So we don't want that to happen again. I mean, it's really ridiculous almost, but it did happen. And so we wanted to prevent that from happening again. So what the law will provide is information contained in a brokerage file or a current or former agent's file of any current or previous defects, adverse conditions, or any repairs shall not be imputed to the broker or any affiliated licensee, and there shall be no cause of action for failure to disclose. So why that is coming about is really from that case. We don't want to have another imputed knowledge case here in Ohio. So that's changed, and I think that's a very, very good change. The next change, it will prohibit dual agency on personal transactions. Right now under the licensing law, let's say you own a property and you have it listed. You technically, under Ohio law, could be a dual agent. You could represent the buyer who's buying your own home and be a dual agent. I wouldn't recommend it. Yeah, we always say you only want to represent yourself. But the way the law is written right now, you could be a dual agent. That will be prohibited. You would not be able to be a dual agent, so you would have to just represent yourself, and the buyer then be represented by someone else or be unrepresented, because the buyer does not have to be represented by a real estate licensee. So it prohibits dual agency on a personal transaction. Also, it'll allow disclosure of seller concessions to appraisers. How this issue came about, under the licensing law provisions, if you represent a client, you have the duty of confidentiality to maintain that confidential information basically forever. There are a few exceptions, but you have to maintain that confidential information. So with this issue, appraisers would be calling and saying, okay, you were involved in this transaction. I need I'm looking for comps for another transaction. I want to be accurate here. What were the seller concessions? What don't I know? And of course, you as representing a client, that's confidential information, the terms of a contract. The only way you could disclose those seller concessions, because you have the duty to maintain confidential information, the only way you could disclose it is with your client's consent, because you can always disclose information with your client's consent. So that was a difficult situation, and so what the licensing law now will make an exception for when an appraiser calls and they're trying, they're looking for comps and they ask about seller concessions. It will be an exception then and not considered confidential information, and you will be able to disclose it, and also it provides no cause of action for disclosing it can be brought against you. So that is dealing with that issue. Allows for advisory letters. The division for years have actually been issuing advisory letters, which really is a good thing. And by that I mean they'll see something that's not being done right by a licensee. What they could do is charge that licensee, or depending on what's being done wrong, issue a citation. But sometimes they'll just issue an advisory letter saying, hey, you're not doing this right, just don't do it again. That's good, that's what you would want, instead of actually having formal charges brought. Well, actually in the licensing law, they don't have it doesn't mention advisory letters. They've just been doing this. So it gives them the ability to issue, officially gives them the ability to issue advisory letters. It also will expand the citation authority. There are certain violations of the licensing law where the division can just issue a citation. They don't have to bring formal charges against the licensee. They can issue a citation. For instance, if you don't have the correct fair housing language, or you didn't complete the agency disclosure statement correctly, they can issue citations for those things. This will expand that to where a broker has a duty to maintain or return a license to the division, changing your address. You have the duty to update your personal address. If you move, you have to notify the division. Right now, if you don't do those things, they can charge you with misconduct. Well, you don't want that. I mean, that's a formal and could be a pretty harsh penalty. So that now they would just issue a citation, which again is a very good thing. Limits assignability of commissions is the next thing. What this is dealing with, really how it came about, are commission advance companies, which there's nothing wrong with commission advance companies, nothing wrong with that at all. The problem was there were some companies that wanted the broker, after this commission advance company gave the agent the money, the broker at the close, they wanted the broker to pay the agent's share of the commission directly to this commission advance company. That's where there was a problem, because the licensing law prohibits a broker from paying a commission to an unlicensed entity. So that is where their problem. What they needed to do was pay their agent, and the agent paid the commission advance company back. Well, some companies didn't like that things had to be done that way in Ohio. So we're making it even more clear in the licensing law now. A broker cannot pay a commission to an unlicensed entity, and no cause of action can be brought against the broker for not paying that unlicensed entity. Because there have actually been some lawsuits against brokers for not paying those commission advance companies the commission directly. So that will help that situation. And the last one is it increases the educational loan limit to $2,000. Right now, while the Real Estate Education and Research Fund can issue educational loans, right now the limit is $800. And what this is for is somebody who wants to get a real estate license and they have to take the pre-licensing courses, they can get this educational loan to take those courses. It was a max $800. That's been raised to $2,000. So that's what that is. Like I said, these changes I just talked about are in the budget bill, which should go, it's proceeding, and it should go as planned. Yes? That's where we still disagree. Yeah, the question was, as far as if a complaint is filed against you with the division routinely does not meet the time frames in the licensing law as far as doing the investigation and charge and all that kind of stuff. We tried to reach an agreement to make that more clear, and we have been unable to do that so far. So that is one area that we're still working on, and hopefully we can get that done soon. Any other questions with that? Okay, I'm going to move on then to social media. Okay, Social media becoming very popular for real estate licensees to use to either promote their services as a licensee or to promote listings that they have. And we're talking about such sites as, well, their own websites, but blogs, Facebook, very, very popular, the social media. One thing that often licensees forget about is if they are advertising their services as a licensee, you know, or if they are advertising properties they have listed, then you are acting as a licensee. And the license law requirements have to be complied with. There are licensing law requirements for advertising. So you have to remember that. First of all, the brokerage name. And I'm hearing this is happening more and more where licensees are advertising and not including the brokerage name. You have to have the brokerage name in your advertising. Online, for the internet, it has to be on every viewable page, which is if you can scroll down the page, you're still on the same page. If you have to click, you're going to the next page, and the brokerage name would have to be on that next page. So definitely you have to include the brokerage name. The prominence rule is the rule where if an agent's name is included in the advertising, the agent's name cannot be more prominent. What that rule actually states is the brokerage name has to be as prominent as any agent's name in that advertising. So I always say err on the side of caution and just make sure that the brokerage name is more prominent than the agent's name, and you don't have a problem. The next thing with the division's proposed rule changes, I talked about the budget bill, which is the Ohio Revised Code provisions. The licensing law also has rules that help clarify and explain the Ohio Revised Code. The division is looking at those rules too. Every so often they have to look at the rules and see if they need any changes. They're in that process right now. One of the issues that came up when they're looking at the rules is there are some websites or social media sites where you cannot comply with all the licensing law requirements because the site doesn't allow you to. For instance, and this is what I've been told with like social Facebook, not the business Facebook stuff, but the social. You may not be able to have the brokerage name on like your front page. Or the prominence rule may not be able to be met. If you can have it, just because of their guidelines and the way it's set up, a social media site, you might not be able to comply with the licensing law. So we've talked to the division about that, and what we're proposing in a rule, and this should be done, it's not finalized yet, but if the terms of use of a site that you're on does not allow you to comply with those licensing law requirements like the brokerage name or the prominence rule, you will be able to link to a display that would meet that requirement. And I think the Code of Ethics also has that same requirement in it. But like Twitter has a limited number of characters, and I've been asked why, I don't have enough room to put my name and the brokerage name on there. And so then in that situation, for example, you could have a link, and that would then include that information. So that's what we're working on with the division on that. You also have the duty to update information on any information you have on your website, well, advertising in general. You definitely need to make sure that inaccurate information is removed promptly, and you don't have a property up there that you no longer have listed and a month later it's still on your website. You just need to make sure that you promptly update that information. So those are the first issues, are just the license law issues that you want to make sure that you comply with. There are a lot of other issues that can come up when you're in social media sites, and a lot of potential liability. And we're just starting to see litigation dealing with blogs and other social media sites. So you got to be careful. Blogs, for instance, those are social media sites populated by user content. You want to make sure if you have a blog, you need to have terms and conditions of use for that blog. You want to make sure, first of all, you have somebody monitor your blog. A lot of problems with blogs as far as anything can be said. I mean, it's, it really is kind of scary. So if you are in charge of a blog, you want to monitor it, and you want to have a takedown policy. So if anybody is engaging in maybe a fair housing violation, or there's a harassment or defamation, you want to make sure you have a takedown policy where you can remove that post from that blog. So you got to be very careful about that. I know the Code of Ethics gets into that too, and it's Standard of Practice 15-3. And it provides, if someone posts a false or misleading comment about a fellow realtor, they have the duty to remove that, and this is if it's your blog. You have the duty to remove that post or publish a clarification when you become aware of it. So you do, if you have a blog, and there are real estate licensees that have blogs, you need to really watch that so that you aren't potentially at risk for what's going on your blog. Copyright laws. Everybody wants to have a content-rich site. That's what makes people come to your site, is if you have good information that people need. However, you have to be careful. If you're putting information on your site that you don't own, you better have permission, because that's how you get into copyright laws and copyright infringement. So you need permission. If you're putting photographs up there, articles, I don't care what it is, get permission before you post it. Okay, so just make sure about that. Let me give you an example of a situation where someone had a blog and they didn't have permission, luckily for them it worked out okay. But this was a case out of Nevada. A real estate agent had a blog on home ownership, and there was an article in the local newspaper on a new federal home ownership program. And what they did is they used 8 sentences out of this 30-sentence article, and then they also had a link to the full article. Well, when the newspaper found out about this information on the blog, they sued that agent for copyright infringement. Now, like I said, you definitely want to make sure you always have permission. If you're posting something that you don't own, get permission from the person who owns it. Well, in this situation, of course, the newspaper owned it, and he obviously didn't have permission because they sued him. But what he defended himself on was the fair use doctrine. And there is actually an exception to getting the permission, and that is the fair use doctrine. Usually where that applies is for educational purposes. So like if I were teaching and I did use somebody else's information as a backup material on something that I was doing, which I wouldn't do without permission, but if I did, I could probably use the fair use doctrine. And that's what he alleged here. I can do it under the fair use doctrine. Now what the court said, we're going to look at 3 things to determine fair use doctrine. Is where you're using it predominantly commercial, meaning real estate licensee, are you just trying to promote yourself and get business for yourself, or is it predominantly educational, where you're just giving educational information to the public? So they're going to look at that, commercial versus educational. Then they're going to look at how much of the article was used. Like I said, in this situation, he used 8 sentences of a 30-sentence article. And then how it affected his use. How did it affect the market for that copyright protected article? So the market for that article. Well, this agent was very fortunate. He was able to use the fair use doctrine to avoid liability. And the reason why is because the 8 sentences he used were dealing with just the facts about that federal program. He did not publish any commentary. So he didn't publish commentary from the writer of that article. He only posted facts about the federal program. That helped him tremendously. Also, he had a link, which was very good. And they said, too, it was predominantly educational, not commercial, because it is a real estate home ownership blog. It's really educational purposes, even though it did have some commercial effect. Of course, he's doing this to promote himself as a licensee, but they said predominantly it was educational. He only used 8 sentences of the 30-sentence article. He had a link, and the 8 sentences were strictly facts about that federal program, not commentary. So that it also didn't really affect the market for that article, because he didn't use the commentary, because the commentary is what really would affect the market for that copyrighted material. So he was very fortunate. But I guess what I want to stress, you don't want to have to rely on that. You really want to get permission before you post anything on your site that is not yours. Fair housing compliance. Be very careful because of the casual style of the internet. You got to be very careful that you don't engage in any fair housing violation. Unfortunately, I've heard about that. I mean, you don't want to get sloppy and, no kid, you're advertising a property, no kids, that kind of stuff. So be very careful about the fair housing compliance. Defamation. Defamation is basically untruth or false statements about someone. Make sure that you aren't doing that for sure. And if you have a blog, because we see these defamation issues a lot, or on blogs, if you do have a blog, make sure you monitor it. And if anybody is going, out of bounds where they shouldn't go, you want to take it down. So just be very careful about that. Antitrust laws. We always caution realtors about antitrust laws. Antitrust, we're talking about price fixing. We're talking about boycotting, group boycotting. I mean, you all know you can't, you are competitors. You cannot get together and as a board or just individual companies get together and decide, okay, we're all going to take listings that last a year. We're all going to take listings for a certain percent. We're all going to co-op in a certain way. We're all going to, give agents a certain split. You cannot do that. You're competitors. Each competitor has to make their own individual business decisions on commissions, terms of your listings, all of that. It is getting into antitrust violations if you would come together as competitors and try to make those decisions. Group boycott. Let's say that a new company is coming into the area and you guys get together and decide we don't like how this company is doing business and so we're not going to deal with it. Again, antitrust violation. I say that because people realize you can't be in a meeting and do this kind of stuff, but I think they sometimes forget on the internet. I see things out there I don't think anybody would actually do in person, but they're doing it. So just be very cautious. You wouldn't do it in a meeting. Do not do it on the internet. Don't give any even impression of price fixing or any boycotting issues. So those are the main things that I want to talk about with social media. And I see I only have 10 minutes and I have to hit the case. Okay, let me go through the cases quickly and then I'll answer any other questions that you have. I have 4 cases that I want to cover. The first case, the Flagstar case, the issue in this case is dealing with a statute of limitations for a professional negligence claim. And the issue is, if you look at the Ohio Revised Code, the statute of limitations for professional negligence is the case would have to be filed within 4 years of the case accruing, okay, or the cause accruing. The issue is, when does the cause accrue? Is it when a person supposedly engages in that negligent act or performs that negligent act, or is it when a person discovers there was negligence and has incurred damages because of that, which, discovering the damage may be way longer than 4 years from when the act occurred. So that's the issue here. This case dealt with a retired appraiser and a former realtor. He was retired now. But it's dealing with appraisals that he did in 2001 and 2002. And he did it for a mortgage company, and there were 3 of them. 2 of the appraisals, they were all 3 sold to Flagstar. Okay, Flagstar held it. 2 of them, Flagstar sold. Both of those properties were foreclosed on, and the person holding that loan had a deficiency. Because it was so recently, I think, sold by Flagstar, they were able to come back on Flagstar. So Flagstar had to make them whole, and so Flagstar incurred damages on those 2. The other one Flagstar actually kept, but there was a fire in the property, and the insurance proceeds did not meet or were not sufficient to cover the money owed to the lender. So again, they had a deficiency on that one too. So 3 deficiency. They went after the appraiser who did the appraisals on these 3 properties, saying that the appraisals we relied on in buying these loans and this paper, and these appraisals were materially inaccurate. And so we're suing you. The issue was they sued in 2008. These appraisals were done in 2001 and 2002. So way over the 4-year time frame if you're looking at when the appraisals were done. So that was the issue here. The appraiser said, well, the case has to be, they wanted it dismissed because it was outside the time frame to even file that type of claim. The trial court agreed with the appraiser, saying the statute of limitations is 4 years from the supposedly negligent appraisal, not from when they discovered. And when they discovered, of course, is when they had to foreclose and they didn't get enough proceeds from the foreclosure sale, and that was down the road. But the trial court agreed with the appraiser. Too long, they're over the statute of limitations, we have to throw it out. Also, the appellate court agreed. However, there's a conflict in the decisions of the appellate courts, and so they certified that conflict to the Ohio Supreme Court. And luckily, just recently, I think it was in April, the Ohio Supreme Court ruled on this issue, and they agreed with the trial in the appellate court, meaning that this case was dismissed. It was outside the statute of limitations. You have to file a professional negligence claim within 4 years of when the negligent, supposedly negligent act occurred. OAR filed an amicus brief on behalf of the appraiser. It was an important issue because professional negligence claims can not only be brought against appraisers but real estate licensees, and they have been brought about against licensees for like misrepresentation, that type of thing. Also, surveyors, accountants are usually where you see the professional negligence claims. So this was a very good decision, and that you don't want, if the bank would have prevailed on their position, who knows how far that statute of limitations would have gone out there. What if they didn't foreclose 15 years, you know, and then they incurred a loss? And they could still come back. So you didn't want that. It's 4 years from when the supposedly negligent act occurred. So that was a very favorable decision. The next case, the Naldi case, this is out of New York. And what this was dealing with, the issue is whether an email would ever be sufficient under the statute and meet the statute of frauds requirements for a writing. For instance, statute of frauds, real estate contracts, contracts for real estate have to be in writing and signed by the party that you want to enforce it against in order for it to be an enforceable contract. So to be an enforceable contract against both parties, it has to be reduced to writing and signed by both, okay? So the issue was, could an email ever be a sufficient writing, meet that writing requirement under New York statute of frauds? And in this situation, it was 2 apartment buildings in Manhattan. A potential buyer in Italy wanted to buy these 2 apartment buildings, offered $50 million for these buildings. The listing agent, so the seller's agent, emailed back and said, well, you know, pursuant to your offer that you made, here's our response, here's the seller's response. We're countering back at $52 million, and due diligence, no due diligence time. However, you can inspect the property if you choose to do it, and we will give you a first right of refusal for 30 days for any, you know, better offer that comes in. Okay, the buyer in Italy didn't officially respond to that. So he didn't write back and he didn't accept, he didn't officially respond. Long story short, the seller sold it to somebody else for $52 million. And this buyer from Italy is saying, hey, I had a first right of refusal. You had to, you know, come to me and see if I would buy it. And so the issue was that email a contract? And something binding as far as the first right of refusal. Well, the court said it wasn't sufficient. And the email, they said the email is sufficient writing to meet the statute of frauds. However, there was no acceptance of that email. There was no meeting of the minds. So they didn't even get to, can the listing agent even bind the seller? They didn't get to that issue. Or the signature part, they didn't get to that. But they did said an email would be a sufficient writing to meet the statute of frauds. The cautionary thing here, and you have some information in your handout material, you never want an email to be considered a contract. That's for sure. You want it reduced to writing and signed by both parties. So you should have a general disclaimer on your emails that that email cannot be considered an offer, a counteroffer, or acceptance, that there would not be a binding agreement until reduced to writing, paper writing, and signed by both parties. So it's a very good idea just to have that general disclaimer on your emails, because you also don't want to be emailing and then have the issue of, is that going to bind your client? You never want to do that. You want it reduced to writing and signed by the client. So that's that case. The next case is dealing with, the Marcus Millichap is dealing with a commercial transaction and a dispute between the broker and the agent over a commission. This was a situation where an agent was with the Ohio subsidiary of Marcus Millichap and was working here for quite some time, had signed basically an independent contractors agreement, the manual specified commission splits, and they had like a tiered system. The more you made in sales, you got a bigger cut. And it also detailed, if you work with another agent, if I call it kind of like a team, how the commission will be split, that kind of stuff. Worked several years, then transferred to the Illinois subsidiary of Marcus Millichap, did not re-sign those documents, but worked there under really the same understanding. Everything was being paid the same. His team member went too, and the commissions when they were both involved were being handled just like they were here in Ohio. Well, there became a problem between the agent and the brokerage, and the agent was going to leave. He told the title company to pay commissions directly to him, not to the brokerage, took company business with him, and also there was an issue of what he was doing. The agent had reached a level that he could get more commission if he claimed that it was just him on the transaction, not this other team member. So what he was doing is he was claiming it and still giving the team member commission. So it kind of was fraudulent from the brokerage as far as what really was going on. So litigation ensued and the brokerage did prevail. But it was kind of funny, some of the arguments he made. Well, I didn't sign it when I went to the Illinois, so nothing applied. And they go, well, you're saying these other things apply. How can you just, you know, pick and choose what terms apply and what doesn't? They go, it applied. It definitely applied. And then he was saying, well, I wasn't an independent contractor, and the brokerage violated the wage labor laws, and they're like, no, they threw it out. But if you want to read it, I mean, it just shows you too, it probably is a good, well, it is a very good idea. The brokerage had very clear agreement with their agents as to how everything is handled, including commission splits. The last case is dealing with who owns the beaches along Lake Erie. Definitely the lake is owned by the state. The issue is the beaches along the lake. And this case was brought by homeowners who have properties along the lake. And the issue is because the state was claiming that the state owned it up to the high water mark. So that's saying the beaches are owned by the state. And the property owners are saying, now wait a minute, we have always had control of our beaches. That brings great value to our property. You can't take this away from us now. I mean, that, you know, it's a private property rights issue. How can you take this away from us? So this case should be decided, well, from the trial and appellate court level, the watermark is where state land and private land is divided by the watermark. And that's basically what the trial court and the appellate court have ruled. The water's edge is the term. So it is now with the Ohio Supreme Court, and they should be issuing a decision at any time. But it really is, again, OAR filed an amicus brief on behalf of the property owners because it really is a private property rights issue because the state really was taking away the beaches that they had always had control over. So that's that issue too. Does anybody have any questions? I know I'm kind of running out of time here. Or if you don't want to say it as the group, I will be happy to stay after for a little bit and answer any questions. Thank you for coming today. Hopefully stay dry. We're supposed to get storms again. I'm tired of the rain, but